If men were angels, no government would be necessary. This profound observation from James Madison cuts to the very heart of the American experiment in self-governance. The founders understood human nature with a clear-eyed realism. They knew that power, while essential for order, could also corrupt and become a threat to liberty if left unchecked. This fundamental awareness shaped every line of the U.S. Constitution, and nowhere is this careful balancing act more evident than in Article 2. This section of the nation's founding document establishes the office of the president. It defines the responsibilities and authorities of the executive branch. It grants the president significant power to lead, but it simultaneously weaves a complex network of limitations to ensure that this power serves the people, rather than subduing them. Article 2 Article 2, in its essence, creates the position of the chief executive. It lays out the qualifications for the office, the method of election through the Electoral College, and the solemn oath the president must take to preserve, protect, and defend the Constitution of the United States. Article 2 grants the president a formidable array of powers necessary to lead a nation. At the forefront of these is the role of Commander-in-Chief of the Army and Navy. This authority places the nation's entire military apparatus under civilian control of a single elected official. The intent was to ensure a clear line of command and the ability to respond swiftly to foreign threats. The president can direct troop movements, plan military strategy, take decisive action to defend the country. This power is immense, granting the executive the ultimate responsibility for national security. It is a power designed for action and reaction, allowing the president to project American strength and protect its interests abroad in a world that can be unpredictable and dangerous. Beyond military command, the president holds significant diplomatic authority. Article 2 states the president has the power to make treaties by and with the advice and consent of the Senate. While Article 2 enumerates significant presidential powers, its true brilliance lies in the limitations it simultaneously imposes through the system of checks and balances. The first and most powerful check on the president is the legislative branch, Congress. The president may be the commander-in-chief, but only Congress has the power to declare war. The president can propose a budget, but only Congress has the power of the purse, the sole authority to appropriate federal money. This means no presidential initiative, whether a new social program or a military operation, can be funded without legislative approval. This dependency forces the president to negotiate and compromise with the representatives of the people, preventing unilateral rule and ensuring that major national decisions have broad support. Further restraining the president's authority, many executive actions require the advice and consent of the Senate. This applies to two critical areas. Treaties appointments. A president can negotiate a treaty with a foreign power for months, but it does not become law unless 2/3 of the Senate votes to ratify it. This ensures that long-term international commitments are not the product of a single individual's judgment. Similarly, the president's choices for cabinet secretaries. American history is rich with examples that demonstrate the system of checks and balances, proving that constitutional limits on presidential power are not merely theoretical. One of the earliest tests involved a conflict between the executive and judicial branches. In 1803, Marbury v. Madison established judicial review. While the case was complex, its outcome was simple and profound. The Supreme Court asserted it could declare another branch's act unconstitutional. This landmark decision affirmed the judiciary could check Congress and the president, ensuring actions stayed within constitutional boundaries. It signaled the president's authority was subordinate to the nation's highest law. A more direct confrontation came during Watergate in the 1970s. In United States v. Nixon, 1974, the court asked if Nixon could refuse to turn over subpoenaed tapes claiming absolute executive privilege. The court ruled unanimously any presidential privilege for sensitive national security info was not absolute. Nixon was ordered to release the tapes which contained incriminating evidence. In conclusion, Article 2 of the Constitution is a masterwork of political design, creating a presidency that is both powerful and constrained. It grants the executive the authority necessary for effective leadership, to command the military to conduct foreign policy to execute the laws. Without these powers, the federal government would be indecisive and weak, unable to protect the nation or manage its complex affairs. The founders understood that a functioning republic required an energetic executive. However, their deeper wisdom is revealed not in the powers they granted, but in the limitations they so carefully constructed. These limits are not flaws. They are the system's most essential freedom-preserving features. They are the very soul of constitutional government. The checks placed upon the president by Congress, the courts, and the electoral process itself are the ultimate guardians of citizen freedom. That is the promise of Article 2, and it remains the foundation of the American Republic.